Good evening to the participants of the Andhra Pradesh and Telangana State JCJ 2023. Karibu sana, welcome in the Kiswahili to my virtual class. And today's topic is the specific relief act, which I already posted in the morning. It is a 1963 virtual class, 8:30 to 9:20 p.m. And without wasting the time, let me go and shoot it. Participants, are you ready? Speak. Yes, it is. The first question goes in this manner. The Specific Relief Act 1963 is an act of the Parliament of India that provides remedies for persons whose civil or contractual rights have been violated. It replaced an earlier act of dash. What is the earlier act of the Specific Relief Act? A. 1874, B. 1875, C. 1878, D. 1877. Participants, which is the right answer? The answer is D. 1877 is the right answer for the first question. Now the second question. Subject to the provisions of dash of the Specific Relief Act 1877, in any suit for the breach of a contract to deliver specific or ascertained goods, the court may, if it thinks fit, on the application of the plaintiff by its decree, direct that the contract shall be performed dash. There are two dashes are there in the second question. The options A, chapter 2 and definitely, and option B, chapter 3 and specifically, option C, chapter 3 and explicitly, option D, chapter 2 and specifically. There are two dash would be there in the second question. And which are the appropriate ABCD option among the four? Participants, which option is the right option for the second question? Answer is B, chapter 2 of the Specific Relief Act 1877, and performed the second dash is specifically. So D is the right answer. Now third question. What is act number of the Specific Relief Act of 1877? I mean old act. I am not asking about the 1963. Anyone? Shia?
Sir, I don't know, sir.
Shoot, even though it is wrong. Punch it.
Maybe 4, sir.
Wrong. It is A. First of the Specific Relief Act of 1877. What about the present act? 1973. What is the act number? Supplementary question. And here I could show you. Supplementary question. What is the act number of the present act? Here. Act number?
47, sir.
47 of the 1963. And this is the current act. Now, if you give me the answer, I will give the Zawadi present to you. Fourth question. How many times dash the word specific relief mentioned in the entire Specific Relief Act of 1963? A, 7 times, B, 8 times, C, 9 times, D, 10 times. I will give the 100 rupees as a gift for this one.
C, 9 times, sir.
You are right. You are entitled for the gift. Okay. I know that your number and you will get the Google Pay or a Phone Pay to you. Okay?
Okay, sir. Thank you, sir.
Right.
It means a lot,
On the day
sir.
you are not present, Lavanya got. Okay, now the fifth question. Which statement is true statement among the four statements? A, B, C, D. Now A, the dismissal of the suit for the specific performance of a contract or a part thereof shall be the plaintiff right to sue for the compensation for the breach of such a contract or a claim as the case may be, but shall not open his right to sue for any other relief to which he may be entitled by reason of such breach. B, the dismissal of the suit for the specific performance of a contract or a part thereof shall bar with the plaintiff right to sue for the compensation for the breach of such a contract or a claim as the case may be, but shall close his right to sue for any other relief to which he may be entitled by reason of such a breach. C, the dismissal of the suit for the specific performance of a contract or part thereof shall be the plaintiff's right to sue for the compensation for the breach of such a contract or claim as the case may be, but shall not close his right to sue for any other relief to which he may be entitled or by reason of such a breach. So the last. The dismissal of the suit for the specific performance of a contract or a part thereof shall be bear the plaintiff right to sue for the compensation for the breach of such a contract claim as the case may be, but shall not close his right to sue for any other relief to which he may be entitled by reason of the such breach. See, these are the 4 ways I made the statement. But among only one is correct, rest of the 3 are wrong. Now shoot, which one is wrong and which one is correct? Of course, 3 are wrong, only one is correct.
Option C, sir.
Option C is the right answer. The rest of the other things are wrong. And here I shown A, but shall not his right to sue for any. The host changed, but shall not open. It is not open, it is not close, it is. For the B, shall not close the right to use for any other thing, but the host changed, shall close. But C, the correct one. In the D, there shall be bar, not the bear. There shall be bar the plaintiff right to sue for the compensation. The host changed there to shall bear the plaintiff right to sue for the compensation. Hence, the right answer is C. Now, the 6th question. Which is the correct sequence or statement by all means? I say correct statement or the sequence. A, the remedies most resorted for the breach of a contract are specific performance, damages, and injunctions in general. B, the remedies most resorted to for the violation of the contract are damages, specific performance, and injunction in general. C, the remedies most resorted for the breach of a contract are damages, injunctions, and specific performance in general. The remedies most resorted for the breach of a contract are damages, specific performance, and injunctions in general. Which is the correct sequence?
Option D, sir.
Option
D.
D.
The 4th one.
The remedies most resorted for the breach of a contract are damages, specific performance, and in general. So that is the right sequence. D is the right sequence. Because first will come damages, next specific performance, next injunctions. That is the right sequence. Okay. The remedies, D is the right answer. The remedies most resorted to for the breach of a contract or damages, specific performance, and injunction in general. Now the 7th question. Unmute and read the 7th question.
The remedy of damages is governed by the Indian Contract Act of 1872, while specific performance and injunctions are governed by dash.
A, Civil Procedure Code. B, Criminal Procedure Code. C, Specific Relief Act. D, Law of Limitation Act.
Performance and injunctions are governed by Specific Relief Act, sir.
WRONG.
No, sir, but injunctions are governed by only Specific Relief
you are
Act, right?
right. You are right. It is by Specific Relief Act. You are right. But Injunction also covered by the Civil Procedure Code. Read.
Okay, sir.
Now, eighth question. This legal statutes main aim is that no person shall live with the damages and losses, and those who have caused such a situation must be in a position to restore all unlawful benefits received by them. The Specific Relief Act focuses on the providing dash to all and not inequitable favoring a single party. A. Equality. B. Equable. C. Justice. D. Just.
I think option C, sir.
Option C
Justice.
is the right answer. I appreciate. Option C is the right answer. Providing justice to all, not equitable favoring a single party. Ninth question. Specific relief can be granted only for the purpose of enforcing the individual dash rights and not for the mere purpose of enforcing a penal law. A. Natural. B. Inherent. C. Civil. D. Statutory.
Maybe C, sir.
It
Civil
is a
rights.
C. C is the right answer. You are right. Lavanya came now. Poor lady. She is not entitled now. Okay, 10th question. Section 20 of the Specific Relief Act 1963 preserved the dash of courts as to decreeing the specific performance. The court should meticulously consider all facts and circumstances of the case. The court is not bound to grant specific performance merely because it is lawful to do so. Now the options are A. Legal discretion. B. Court discretion. C. Judicial discretion. D. Justice discretion.
Option A, legal discretion.
If the option A is there, it's a wrong answer. Second option.
Option B,
B,
sir.
B, court discretion.
B. Court discretion. WRONG.
Judicial discretion, sir.
It is a judicial discretion. C is the right answer. It is a judicial discretion. C is the right answer for the 10th question. Now 11th question. If any person is disposed without his consent of dash, property, otherwise than due course of law, or he or any person claiming through him may by suit recover the possession thereof, notwithstanding any other title that may set up in such a suit. Option A, movable. Option B, immovable. Option C, tangible. Option D, intangible.
Option B, immovable property.
Yes, it is a immovable property is the right answer for this question. Now, fourth question. Section 21 of the Specific Relief Act 1963 provides that the plaintiff may also claim dash for breach of performance by defendant in addition to a claim for the specific performance of a contract. A. Injunction. B. Specific performance. C. Compensation. D. Damages.
C, compensation.
Sir.
Yes, you are right, both of them. Arshia and Lavanya. C is compensation is the right answer. Now, 13th question. In the event of a situation not covered under the 1963 Act, the Indian court can exercise their inherent power in the terms of dash of the CPC. A. Section 149. B. Section 150. C. Section 151. D. Section 152.
C, 151.
C, sir.
Yes, the C is the right answer. It's the C, 151 is the right answer. Both are right today. 14th question. Anyone can unmute and read 14th question.
Laws fall into these categories. Option 1, those which define rights. Option 2, those which define duties. Option 3, those which define remedies. Option 4, those which define procedure. A, 1 plus 2 plus 3. B, 1 plus 3 plus 4. C, 2 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4. Option D.
Option
D.
1 plus 2 plus 3 plus 4.
Yes, sir.
WRONG.
A. 1 plus 2 plus 3. Duties, rights, remedies.
WRONG.
1 plus 2 plus 4, sir.
There is no, generally law falls into the category number 1, those which defines the rights. And there is no duties generally, those which define the
1
rights.
plus 3 plus 4.
Those which define the procedures only. I intentionally kept it because when you see the rights, immediately your mind say duties. So it is 1 plus 3 plus 4 is the right answer. That means B is the right answer. Is it clear?
Yes, sir.
Now, 15th question. The law of specific relief belongs to which category? I repeat the question. 15th question. The law of specific relief belongs to the which category? A. Number 1. Those which define rights, first category. 2. Those who define duties, second category. 3. Those which defines remedies, third category. And 4. Those which defines procedure, fourth category. Answer A. 1, B. 2, C. 3, D. 4.
Option
C.
D, sir. 4.
If they say Ashia, option D, you are wrong.
C3, sir. Third category, remedies.
C is the 3 is the right category. Because it is remedies. The law of specific belongs to the category of the remedies. But in the generally law, right, remedies, procedures. Is it clear?
Yes,
Yes,
sir.
sir.
We say specific relief, it's only remedies. It is not about rights, not procedures. But when you say the law, it is the rights, remedies, and procedure. 16th question. It goes in this manner. The Specific Relief Act deals only with certain kinds of the equitable relief, and these are now, number 1, recovery of possession of the property. 2, specific performance of the contract. 3, modification of instrument. 4, rescission of contract. A, 1 plus 2 plus 3. B, 1 plus 3 plus 4. C, 1 plus 2 plus 4. D, 2 plus 3 plus 4.
C. 1 plus 2 plus 4.
C, 1 plus 2 plus 4 is the right answer. Because recovery of possession of property is there and specific performance of the property is there and modification of instrument is not there. It is nothing but rectification of instrument is there. Hence the right answer is C, 1 plus 2 plus 4 is the right answer. So 17th question. The Specific Relief Act deals only with certain kinds of the equitable relief and these are now, number 1, annulment of instruments. Number 2, cancellation of instrument. Number 3, declaratory decree. Number 4, injunctions. Options A, 1 plus 2 plus 3. B, 1 plus 3 plus 4. C, 2 plus 3 plus 4. D, 1 plus 2 plus 3 plus 4.
C. 2 plus 3 plus 4.
C, 2 plus 3 plus 4 is the right answer because there is no annulment of instrument is there. It is the cancellation of instrument is there, declaratory decree is there, injunctions are there. Okay, now the feedback is there is no annulment of instrument, only cancellation of instrument is there. 18th question. Match the following part A to the relevant section part B. Number 1, when can the specific performance be awarded? 2, when can be the remedy for specific performance not be awarded? B, who can claim the specific performance? 4, who cannot claim the specific performance in the part B, section 16, B, section 14, C, section 10, D, section 15. Now, match the following. A, 1B, 2C, 3D, 4A. B, 1C, 2D, 3A, 4B. C, 1C, 2B, 3D, 4A. C, 1D, 2C, 3B, 4A.
Option D, sir.
WRONG.
Option C, sir.
Option C is the right answer. Option C is the right answer because feedback is who can specific performance be awarded section 10, who can be remedy for specific performance not be awarded section 14, who can claim specific performance section 15, who cannot claim the specific performance section 16. Is it clear?
Yes, sir.
So 19th question. A writer refused to have his name published as the author, which had been re-edited and altered by a magazine expressing other opinion in a different style. He was not entitled to specific performance of his contract as that would require supervision by the court of editing the article, though he would not be entitled to damages for loss of opportunity of enhancing his reputation decided in the case of Dash. A. B. Santoshama versus D. Sarala. B. Joseph versus National Magazine Company Limited. C. State of Gujarat versus Bihari Lal. D. Sartaj versus Ayub Khan.
B. Joseph versus National Magazine Column.
Right. May I know that how did you make it out? Only you hunched and shooted, or you read something?
Magazine was there in the question as well as in answer.
Yeah. I appreciate. Yeah, that is the way that you have to make it out, even though you don't know the right answer. Yeah, 20th question. Declaratory decree provision bring out to merely perpetuate and strengthen the plaintiff in case of an even adverse attack so that he attacks on the plaintiff can't weaken his case, and it is mentioned in the case of Dash, and by that arrangement made in this case, it encourages the plaintiff to come forward to enjoy the right which they are entitled to, and if any defendant denied the plaintiff from providing any right for which the plaintiff entitled, then it gives them the power to file the suit and get special relief. And it is decided in which of the case law? Number A. Tarak Chandra Das versus Ankul Chandra Mukherjee. B. Prem Singh and other versus Birbal and others. C. Naganna versus Sivannappa. D. Prem Singh and others versus, I repeated, Birbal Singh and others. Which is the right? Thank the A, B, C, D. Shoot.
C, sir.
C is the right answer. Naganna versus Sivanappa is the right answer for this question. So the 21st question. In the case of Dash, it was held that the appellant filed a civil suit with the allegation that the plaintiff purchased the property, that is land within parentheses, from the defendant by the registered sale deed for valuable consideration, but due to inadvertent mistake and misunderstanding in the sale deed, they are taking undue advantage of the same. In the judgment, it was held that the appeal is liable to be allowed, and the judgment passed by the lower appellate court is liable to be set aside, and the judgment and decree passed by the trial court are liable to be restored. In which case law it is decided? A. B. Santoshama versus D. Sarala. B. Sarala Mohan Singh versus Mangailal. C. Sartaj versus Ayub Khan. D. Prem Singh and other versus Birbal and others.
D. Prem Singh and other versus Birbal.
WRONG.
Option A, sir. B. Santoshama versus D. Sarala.
WRONG.
C, sir.
C is the right answer. Sarchad versus Ayub Khan is the right answer. Lavanya, you joined later. I put Zawadi 100. Now, of course, Arshia got it, but let me check your IQ also. Yes, be ready. Fourth question. How many times the word specific relief mentioned in the entire Specific Relief Act 1963? A. 7 times. B. 8 times. C. 9 times. D. 10 times. Okay, hunch. I would like to test.
See 9 times.
I appreciate. But you are not present at the time. And hence, only Arsha got the prize. You are not there because you did not come over there. But I appreciate. Now, I am sure that Arsha and Lavanya definitely cracked it. No doubt at all. Because you know the how to guess it. You know how to hunch it. Because I trained you in a such a way, you are hunching and you are guessing definitely hit the target. No doubt at all. I don't have, but be regular and read before coming.
With all your blessings, sir.
No. Your work also there. See, I am not a king now. I am a kingmaker. I am not a king now. I am a kingmaker.
Of course, sir.
But you are guiding us, no, sir.
Yes, sir. See, supplementary questions.
You are training.
How many parts are there in the Specific Relief Act 1963?
3 parts.
I appreciate. How many sections are there in the? How many sections? I don't show the.
44, sir.
44.
Let me check it whether you are right or wrong. 42 sections are there, and schedules are there.
Sir, 43 is
42 are
amended and
there.
44 is repealed.
Yeah, yes, because now, and 43 is not also there, they are repealed. And schedules are only one schedule, but that schedule, they may ask the question, the schedule connected to the which section? You should say
20.
the schedule connected
Infrastructure
to the
projects.
section 20 capital
28.
A and 41 small HA. But in the multiple choice, they will give you like that. 20 is capital A and 41 or something, I can change it. 20 capital B and I will change it. And hence, you can ask, because these are the supplementary questions. Of course, nobody would ask generally, but they may ask you. And last time I asked this question. In schedule, what are the categories are made? In my last class, you check it, my video, I asked this sequence: transport, energy, water and sanitation, and communication, and social and commercial infrastructure. No, yeah, only four I asked. Fifth one, social and commercial infrastructure. Which is the right sequence? I asked. Because I framed it,
Yes,
so I
sir.
could know it. I asked which is the right sequence? I jumbled it. I put the energy, I jumbled it by asking this question in the schedule, what is the right sequence? So that is the way we can make it out. And again, I did not ask you this. How many sections are repealed? Is there any repealing sections here? Today I did not check it. 43 is repealed. 44 is
2
repealed.
sections.
Repealing section. Then any other section? Repealing section? I believe only 2.
2 sections.
Yes, sir.
So they can
Only
ask
2.
you the question. I think this I asked in my last class. In my last video it is there. Because I generally frame in such a way, what are the acha? Again the question is supplementary question. How many times Specific Relief Act is amended? Please note the point. This is also very
2
important.
times, sir.
Because
3.
I did not go through it, but if you check it like this, when you say 14A, means definitely it is. See, 14 capital A is there. When you say capital A, it is amended, but they cannot make the provision, and that's why they made 14 capital A. Correctly. And again 20A is there. Again 20B is there. 20C is there. So supplementary question. I think I asked it in my last question, this thing, in my last class. 20 Match the following. 20 substituted performance of contract, 20 capital A special provisions, 20 capital B special codes, 20 capital C expedition. Yes, I asked you this question. Match the following. So because I found it 20, 20A, B, C. So naturally, any examiner, if a keen examiner will be there, no, he will say either mismatch it or match it. One of it. And another examiner also there. Which chapter is having only one section in the Specific Relief Act? Supplementary question. Chapter 3.
Chapter 2, sir.
Chapter 3.
Certification. 26.
And here, when instrument may be rectified, 26. That is chapter 3. Okay, let me check it from first. And chapter, no, there is no part 1, part 2, there is no. Part 3 also no. Then only chapter 3. Chapter 4, no, it is a 4 are there. And chapter 5, 3 are there. And chapter 6, 2 are there. And again, it is given in the chapter 7, there are 36 are there. Yet 37 is there, 2 are there. And chapter, the right answer is chapter 3. Is it clear?
Sir.
And as you said, there is only part 3 are there. Part 1, part 2, part 3. Of course, they don't ask such a question also. How many sections are there in part 1? How many sections are there in part 3? And how many sections are there? Very rare probability is to ask such a question. Very rare probability. But they may ask you, how many chapters are there in part 1? How many chapters are there in part 2? How many chapters are there in part 3? Yeah, probability is there. Probability is there, they can ask, because when you see the part 3, it is only 2 chapters are there. What are they? Chapter 7 and chapter
7 and 8.
So probability is there, they may ask such a question. Because 2 remote questions they cannot ask. How many sections are there total? Is too remote. Unless there is a close comparison is there. Close comparison, like I will give the close comparison means what? In part 1, 3 chapters. Part 2, 3 chapters. Part 4, 4 chapters. That means close comparison is there. At that time they can ask the probability is there. And another probability also there. If the part 1, same chapters. Part 2, same chapters. Part 3, same chapters. Part 4, same chapters. They can make you confusion. They can give different order. And they say, mismatch the following. They can use such a way also, because probability is there to check it, whether he is having thorough knowledge regarding the. Of course, we cannot remember everything, each and everything. No, we can use only our logic. We can use only our x-axis, y-axis, z-axis. Means all 4 dimensions we can make it out. And in the 4G we have to shoot it. Is it clear?
Yes, sir.
Yes, sir.
So you have to use the permutation and combinations. You apply one formula and see whether it suits or not. But when you look at the question, you know which formula could be applied. When you read the question, automatically your brain will make the formula in your brain. Oh, this equation we have to apply. Immediately you apply it, I can shoot it. That is the right answer. Even though you don't know that. Now, Lavanya, now you tell me, how did you know that is 9 is the right answer? There is a C. I asked Arshia also the same thing. But he used his intuition. But you are not studied and you don't know that I am going to ask such a question also. But you can tell only at the time when I show the options. If I don't show the options, and it's a very difficult task to make it out. Right?
Yes, sir.
If I show the options, you can shoot it. But if I don't show the option, no. Even myself also I cannot. Even myself, who framed it, I cannot. But if I show the options, even though I did not read it, but I can shoot it. Because the sixth sense goes and they say it may be the right answer. So generally that is the way that we have to shoot it and you have to make it. And the tomorrow class there is a Telangana is there, but it compulsory with the both the things will come. Not only Telangana, it Andhra also comes over there because there is no such separate Telangana. The same thing is they changed only the nameplate they have changed. What they changed?
Only nameplate.
Only nameplate they changed. See, when you see the 27th, they say 28th, tomorrow is 28th, no? Here it is. Tomorrow 28th March, Telangana Excise Act, no. Telangana and Andhra Pradesh Excise Act is there. Of course, a little changes they may make it out like we did it in the Prohibition Act. Telangana Prohibition Act and Andhra Prohibition Act we made it. Slight changes we made it. Can you tell me that? I would like to check your memory. In Telangana Prohibition Act, which sections are repealed? In Andhra Pradesh Prohibition Act, which sections are repealed? I would like to check your memory.
Prohibition Act is not there for an AP syllabuses. So we haven't.
Yesterday I was dealt it, no, I told it. And section 27 and 17,
16, sir.
16, yeah. And in the AP, what is that AP?
Section 35. Section
Yes.
35 and
27 and 35?
in Andhra Pradesh, sir.
Yes. Okay. So these are the things which I made it out. How many times are there? It is repealed and how many times it is made it over there. So you have to make it. But still there is time, I believe. But I covered. But supplementary questions you can frame it from here, which I have shown just before, is Specific Relief Act. Yes, this is the thing. Of course, almost all we covered it in this, but the cases we can shoot only by our IQ only, because rare places we can read the cases. He can give the case any nook and corner also. That's why cases, when you read it closely, the facts, where it is decided, and who are the names of the persons, plaintiff and defendant, and by that we can easily make it out. The case law belongs to the so and so when the case names are given. So that is the way that you have to make it out and how to shoot it. So I am showing the way how you can catch the fish in different environment, in different places, in different areas. So the same technique would be there, but little variation would be there from area to area when you fish it. In the same way, here little variation would be there. Generally, how do you tackle it regarding the statutes are concerned. So with this, I would like to wind up today class, but still there is a time is there, can make it out. But I exhausted all my questions, so I would like to go out because still we do have some 15 minutes would be there to break my fast here. Still I did not break my fast. And 6:41 is there. Generally we break the fast here at 7 o'clock, means India time is, now the India time is 9:11. Am I right?
Sir. Yes, sir.
Now
Yes,
your
sir.
time is 6:41.
9/11.
Yes, 9:11, because I started